Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This year, we have a number of exciting and important issues to discuss. Frank will talk through some challenges to state pro-life laws that are pending before state Supreme Courts in Wyoming, South Carolina, and Oregon. I'll walk through some proposed expansions to physician-assisted suicide laws in Vermont and Oregon, and then we'll conclude with a rehearing of a case that addresses gender issues, healthcare, and insurance coverage.
All right, there's a pretty stacked agenda, so let's get right to it. So the first topic, there are currently challenges to pro-life statutes that are on the books in Wyoming, South Carolina, and Oregon. They're pretty similar in structure. I'll just lay out a minute on each one to let you know what's going on. And then I just have a couple of comments about this general trend of pro-life laws on the state level and the court's responses, because I think there's going to be a lot more of this coming. And now that Roe versus Wade and Casey v. Planned Parenthood are no longer the law on the federal level, this is where the legal battle is going to be fought over abortion restrictions. And so let's get into it. So the Wyoming case, last November, a state court in Wyoming struck down two pro-life laws that almost entirely banned abortion. I believe they were heartbeat bills or very similar, somewhere around 6 weeks. The abortion ban kicked in. So shortly after that state court ruling, the Wyoming governor vowed to appeal this court's decision. The Attorney General's Office of Wyoming filed an appeal to the state Supreme Court this month. So this case will go up to the state Supreme Court. And the pro-life laws protecting unborn children from abortion are paused. So they're not currently in effect right now. Wyoming has legal abortion up to the point of supposed viability. I think it's 21 to 24 weeks of gestation. South Carolina, the Supreme Court just heard oral arguments. There's a state fetal heartbeat and protection from abortion act in effect in South Carolina. Also, a heartbeat bill bans abortion after a heartbeat can be detected, which is usually around 6 weeks. That law has been in effect since 2023. Planned Parenthood challenged it. I don't think this is their first. I think the South Carolina one is the case where there have been like two or three unsuccessful challenges to the law already. One interesting thing to note, Planned Parenthood stated that its abortion business in the state of South Carolina has dropped about 75% since the new law went into effect. So they're making it pretty clear that these laws have a huge effect on the abortion industry. The judge in the lower court in that case made it pretty clear that the judiciary would not unconstitutionally override, his words, the will of the people and of the General Assembly and their clear desire to protect life. So unlike the Wyoming case where the lower court struck the laws down pending the review, in South Carolina, those laws are still in effect pending review from the high court. Finally, in Georgia, the state has a Life Act, which is a 2019 law that recognizes unborn children as human beings and so bans most abortions when a heartbeat can be detected. Lower court declared the law unconstitutional, but the high court, the state Supreme Court, agreed to hear the case and stopped the lower court's ban. So that the pro-life law is currently in effect. And while this case is being heard, this one has actually gotten a lot of national attention. 19 different states have actually intervened as with amicus briefs in support of the Life Act, including the Attorney General of Indiana, I believe Attorney General of Florida as well, and there are several other states who were involved. So the argument here, they're all very similar. The argument here is whether Georgia's constitutional right to privacy extends to permitting abortions. And the amici in the Georgia case are arguing particularly about this issue, that Georgia's constitutional right to privacy does not extend to permitting abortions, and that abortion is never a treatment for a mental health condition, which I guess is part of the challenge to the Life Act in Georgia. So they're all very similar. These are state, essentially heartbeat bills passed for very different. I apologize. We were saying Oregon in the title, which is incorrect. Of course, the last one is Georgia. Sorry about that. That got into our notes and just threw me off there. But anyway, I would expect this to be a trend, right? This was what the I think, rather moderate ruling in the Dobbs decision, and what the current administration, President Trump, said all through the 2024 campaign. This was not a hard line, abortion is now illegal everywhere. That was not the result of Dobbs. And that's not really what anyone was, except for some pro-lifers obviously want the full ban of abortion for obvious reasons, but that's not what this did. This was, it goes back to the states, it goes back to the people's representatives to make the decisions that they haven't been allowed to make for 49 years, right? Because Roe and then Casey shut down the debate, said abortion's a constitutional right, you may not stop it, period. So there was no discussion, right? No popular policy discussion about whether there ought to be abortion or whether it ought to be restricted, how restricted. We just shut that conversation off in 1973. And then all of a sudden, Dobbs came down in 2022 and like reopened as an issue. So I guess my first point is this is all very much to be expected, right? Roe v. Wade and then Casey took this off the table. All of a sudden, it was put back on the table after 49 years of people assuming that abortion is a constitutional right, right? So when all of a sudden you pull that and say, no, we're going to go to what the Constitution actually says, or in this case doesn't say. It's not a constitutional right. We need this. This can be legislated on either way. So this sent shockwaves through the abortion community, right? People were used to abortion as a right. They were not going to simply accept that. Oh no, I guess it's not a right. We'll just move on. So when pro-life states or states with pro-life legislators start to pass and enact pro-life laws that are restricting or banning abortion, again, utterly unsurprising that you're going to see these legal challenges, and that you're also going to see state level judges who are open to these conversations, these arguments about it being, a woman has a right to privacy, that includes a right to abortion. These statutes are infringing on that right. Again, this is language and a concept that we've been used to for so long that it's not really surprising. The other thing I'll say on this is most of these arguments that are being accepted by some of the pro-abortion judges, like the Wyoming case, they hinge on two parts of an argument, right? So the first one we just discussed: a woman has a constitutional right to abortion via some supposed, usually it's a right to privacy now in the state constitution because you can't rely on the federal constitution after Dobbs. So that's the first part. Woman has a constitutional right to abortion. But then part two for this argument to work is it has to be taken for granted that the unborn child is not a person with legal rights, right? Because if the unborn child is a person, then you now have a real conflict of rights, like in this case, the right to life, right? So the trial judge in the Wyoming case articulated this exactly. Here's a quote from her. She says, "The court cannot reconcile how a small group of prenatal cells, such as a zygote, that has only the potential of life, can trump the fundamental right of a living, breathing, pregnant woman to make her own medical decisions," right? So if the first argument about the women's right to privacy and therefore abortion is being taken seriously, it seems to me that this is the future of the legal battle over the constitutional abortion issue for the pro-life movement to really embrace and start to clarify and define and flesh out the personhood, the legal personhood of the unborn child. Because if you phrase it the way that the Wyoming judge does, then of course you're going to come out the way she did, right? Woman has a right, and then you have this clump of cells is almost exactly the language she's using, right? And we've been accustomed to this kind of language for decades. The clump of cells doesn't have a legal case, so we're just talking about what rights the woman has. But if it's a baby and the baby's a person, persons have rights to life, liberty, and property, right? That's a constitutional right. Then we have a very different issue. And I think this is going to be key, and we're going to want to watch how this plays out in the years to come, because again, when Roe and Casey were the law of the land, we've had many years where these arguments were just not on the table. And then when Dobbs was in process, there were some more full-fledged right personhood adherents. We follow a lot of them. I think Mary Margaret, they're good scholars at EPPC, at the James Wilson Institute. A lot of others, a lot of good writers who did work on this at First Things magazine when Dobbs was being decided but had not yet been decided, arguing that that an unborn person, at least at a certain point in the gestation process, becomes a legal person, and that there is actually good legal precedent, right? You can go back to Blackstone and the commentaries before the country was even fully founded, but that was very influential on our country's jurisprudence, arguing that once quickening had taken place, which in the 18th century, that's the point at which you can tell that there's a life, right? When the baby moves. And so it was pretty well argued that, once there's a moving baby, it's a person and that certain rights vest. And that's why you can have double murder if you kill a pregnant woman in certain jurisdictions and situations. So I think there was a lot of fear of even going there, right? A lot of pro-lifers were like, let's just get Roe and Casey overruled. We don't want to assert, a personhood argument that's extreme. But legally, I think it's quite tenable. And I think you will see people start to articulate. I think now they have to, or else we're going to keep having pro-life statutes challenged and often defeated if we don't take this argument more seriously. So I think this is the next chapter of the legal battle over the rights of the unborn. Mary Margaret, I know that I just said a lot. So if you want to weigh in, please feel free.
That was an awesome overview, Frank, and probably worth a special episode at some point. There's, as you said, it's really heartening to see the robust deliberations taking place as they should around this important issue. And like you said, there was almost this gag order for 40 years where any discussions about personhood were basically academic. I mean, and now we're actually seeing these arguments taken back to where they should be, and really, yeah, brought back into reality and out of the ivory tower where they had been banished by Roe. I think there were three points that stood out to me with these laws and the cases associated with them. I think the first one is, you noted in the South Carolina case that the challenge is brought by Planned Parenthood, and I just wanted to make the point that the standing issue in these cases is, so the reason that Planned Parenthood is allowed to even bring cases challenging pro-life laws is, I would say, is the result of a legal fiction. They should not be party to these cases in my mind, because there's a conflict of interest there. It's and I can't recall the exact case, but this was kind of established. I think they're sort of standing in person in the place of a client is how this was argued, or in place of a patient. But I would love to see some challenges to that jurisprudence, because I think that is flawed at its root and flawed in its results. And then I think the second point is just related to the Georgia, the life law. You alluded to this, Frank. That law actually makes the case that unborn life is a human life, and so it provides and restores like the correct protections to that. And I think that you kind of alluded to this, but I think it, to use a DC term, it's an important shift in the Overton window. So for those of you who haven't heard that phrase, that just refers to what's kind of the spectrum of kind of feasible, plausible, politically acceptable proposals that will be taken seriously. And as you said, Frank, for a long time, proposals about the personhood of the unborn were pretty much ivory tower. And now I think we're realizing the Overton window is shifting, and we can now go back to saying not only like should there be protections around viability, but this is a human life from conception. And I'm thinking of a friend, Cesar Bernstein, who wrote some outstanding scholarship on the personhood of the unborn. And at the time, it was a little bit more academic, and now I think it's something that can be referenced in these types of cases. And then finally, I think we've talked a lot about just the healthiness of state deliberation and debate around all important issues, but in particular pro-life issues. And so I'm really looking forward to seeing these cases continue to move forward. And there will be some wins and some losses, but the bottom line is the process is once again a healthy process, I think.
Yeah, that's a great point. One thing I'll just harken back to a couple weeks ago, we talked about that case where I think it was a parental bill of rights type of case in is it Montana, where very conservative populist, conservative governor, conservative legislature passed this law to protect children, and the court, very out of step with that state, but also kind of on spurious constitutional grounds, had struck down this law saying that children, minors, have certain like rights to, I think it was a gender transition case, but I think just a similar thought in Wyoming, that when you have, a very naturally conservative state that elects rather conservative leadership, and then for courts to step in and strike those laws down, I just, state judges are either appointed by their governors or they're elected by their people. And I think you will, when you see these very conservative states passing laws and then having judges who seem to be very out of step with where those states are headed, I would expect electoral and political challenges. And I just think that's coming in some of these red states, and I'll kind of leave it there. Is that when the judges seem to be that out of step with what's clearly going on in these states, I don't think that will just be left by the people and by the politicians there.
Yes, I think you're so right. I think yeah, I think there's a level of accountability that we haven't seen before, and that's encouraging. So I'll move over now to our first discussion of what is called a assisted suicide bills. So we're looking specifically today at bills in Vermont and Oregon. But since it's the first time we've discussed the topic of physician assisted suicide on the podcast, I wanted to give just a brief lay of the land and explain why is this an issue of religious freedom and why is this an issue for faith-based nonprofits? So when you're thinking of physician-assisted suicide, there are kind of three legal questions that come up. The first is the question, must the state permit physician-assisted suicide? In other words, is there a fundamental right to physician-assisted suicide? And this was explored in the Washington versus Glucksberg case, which was decided by the Supreme Court in 1997. And the Supreme Court determined that there is no fundamental right to physician-assisted suicide. I do think that conclusion was maybe challenged in like a footnote or something in a 2018 case. I think it was Obergefell, but in any case, it's still good law. And so at this point, at the federal level, the U.S. constitutional level, there's no fundamental right to physician-assisted suicide. So that leads to the second question: may a state permit physician-assisted suicide? In other words, can Illinois legalize this? Can California legalize this? The answer is yes, they can, and I believe it's 11 states that have at this point, to some degree. And then finally, the last question is: if a state does legalize physician-assisted suicide, must healthcare providers, systems, insurers participate in that process? Must they be complicit? And that's, as you can imagine, where the religious liberty issues come in the most express sense. I think the first two are kind of culture of life questions. And then the last one is where that coercion comes into play, where you have physicians and nurses who believe that this is, frankly, this is the ending of the life. This is a form of murder, and they don't want to be complicit in it. So that was explored in most recently in 2022 in an ADF case, Christian Medical and Dental Association versus Bonta. I believe that was settled out of court in 2023, but it just explored some of these issues of complicitness, and then discriminatory treatment towards healthcare professionals who were opting not to participate in the state physician-assisted suicide program. So we're looking specifically now at two bills in Vermont and Oregon that would expand current physician-assisted suicide bills in those states. So I think it's helpful to just think, okay, what are the kind of the basic elements of a physician-assisted suicide law? And it kind of just falls along the lines of who, what, when, where, why. So the laws, they look at when can a physician-assisted suicide happen? Originally, there were pretty long waiting periods, 40 days, 3 weeks, whatever. In a number of states, this has been shortened to 48 hours. I know California has just like a 48-hour waiting period. With the question of where, initially, there was a desire, a consensus, a belief that that would be illegal to allow kind of like suicide tourism. And so there was a residency component where you could not receive suicide, or you could not, I guess, commit suicide. I don't know what the language is, but you could not commit suicide in a particular state unless you were legally a resident of that state. And that was, again, to deter people from kind of traveling to do these processes. And then what were the kind of safeguards in place? Historically, there had been like consultations required, kind of like a multi-phase course of treatment. In many states, this has been shortened to basically teledoc. So a lot of states a lot of states that have these are exploring or have already permitted, like a virtual consultation is adequate. And then, who can actually sign the prescription or sign the order that will ultimately affect the suicide. So in all 11 states where this was allowed, this was where suicide was allowed, a physician needed to be the one who made the assessment, looked at the various kind of treatment options, whether there was like a mental health component that should be treated, et cetera, and then concluded that this was the right course of treatment. What Vermont and Oregon are looking at doing now is editing their bills or amending their bills, their laws, so that suicide prescriptions can be signed by like a physician assistant or a nurse as well as a doctor. And so basically this is a red line changing the language physician to, in Vermont, clinician, or in Oregon to provider. So this is really I think an area that we all should really be praying about. There's a lot of compassion needed for the patients who are exploring this. It's obviously a really heavy cross to be exploring something like this. It's also just a really grave matter, and I think there's grave cause for concern to see states lowering the barriers to entry, because when you think of the good of the patient, um, lowering the barrier to entry doesn't really seem like it does anything good for someone who's kind of in this position where they think it would be better not to be alive anymore. In the 1997 Washington versus Glucksberg case, when the Supreme Court discusses some of the rationale and policy considerations related to physician-assisted suicide, they talk about just how susceptible this could be to misuse. So pressure given to someone who's already kind of mentally worn down, discouraged, physically exhausted, coercion, even, like, for lack of a better term, kind of like the brainwashing that people can be vulnerable to. And so there's just so much cause for concern, and there's so much that I found disturbing researching these laws. And so I think we need to be praying and advocating for patients. And I want to commend the work of the Patients' Rights Action Fund, which is led by Matt Valiere. They've done a good job outlining the current state of the law and then actually advocating for the rights of patients, and telling the story of people who explored the possibility of suicide and then were actually given the care they needed and able to live in short. So yeah, there's so much to talk about, Frank. I would love to hear your thoughts on these specific bills, or just the overarching issues here.
Yeah, one thing on the overarching issue is that we've talked about this before, and I'm sure it'll keep coming up, that the law is a teacher, right? It prescribes what we should and should not do, right, for the good of the people. So obviously law can't force people, but it does have teaching power, right? If the law says something is illegal, it signals to people that they shouldn't do it, right? And if something is lawful and regular, then it signals to people that they can licitly do it. Right now, obviously, immoral laws can be passed. So one of the issues here, I think, and I've read a lot of testimonies on these kind of things from, you get people who are maybe an elderly parent who doesn't want to be a burden on their children, or somebody who's, get terminally ill and just doesn't want people to spend the money or the time or the heartache that it takes to care for like a terminally ill family member. And so obviously as Catholics, to care for these people, the lonely and the sick, is a duty and even a grace, right? It's good. Like in our own family, we've had, my wife and I, and then as we've had little kids, have always tried to make it a point to go visit the elderly, the sick, the dying family members, because it's good for the lonely dying family member, but it's also good for us, right? It's an act of charity, and it's a good way to build the bonds of family, of community with love, right? So I think when you legalize physician assisted suicide, besides the moral case that you should never do that, but you're really creating such a problem because you're shifting the culture to say that, like, no, these are not people to be loved and taken care of in their hardest moments. They're people that you can dispose of, right? Like that's not what how the laws are worded, but that is the message that it's sending to both the healthy younger family members, but also to the sick or elderly person people themselves, right? That like, well, why should I burden my kids with the money, with the time, with having to come visit, with having to deal with me? I'm getting old, I'm sick. Like, I have this legal option to make myself not a burden to anybody, right? So I really worry about that. Besides what you had said, Mary Margaret, very well about you really don't want to offer this as an option to people who are mentally in turmoil, either because they're terminally ill or they're going through a hard time. That's not prudent. But also, if people are feeling like a burden, you shouldn't give them something to say, here, well, you can stop being a burden by killing yourself. I just think there's a lot of really negative teaching going on with such a law. Um, I could, I think I'll leave. I mean, I have so many thoughts on this case. The one other thing I'll say, though, is practically on these bills, I think it's really disturbing, putting aside the moral question of whether you should ever have physician assisted suicide, which I obviously think you should not. But the expanding the classes of workers from physicians to like clinician, practitioner, more generally to bringing in nurse practitioners, I think, right? And yeah, and physician assistants, this is troubling for a different reason. One of the commentators in one of the articles we cited when we were reading through this had said, if if your nurse comes in to the doctor's office and while they're like starting up the appointment, they give you 6 months to live. Like, do you trust that diagnosis or do you wait to talk to the doctor? Right? Like, these are grave matters of life and death are properly within the realm of a doctor. That's not no disrespect to nurses or physician assistants. They do important work, but it is different. They're not supposed to be scientifically diagnostically doing what doctors do, right? They're giving certain levels of care. And so I think to open up something as dire as prescribing death to non-doctors is just it's very disturbing. And I think I'll leave it there. So do you have anything else on this issue or do you want to move on?
I mean, there's so much to say. I think you put it really well. I guess I'll close with just a note to your point, Frank, that what does this mean for faith-based nonprofits beyond the legal and the moral considerations? The fact that this is gaining traction is a sign that something went deeply wrong at some point, in the narrative around suffering, in the narrative around the value of human life. And so I think what we should all be looking to do is exactly what you're doing, really making a point for ourselves, our children, our families, to show them the value of life, even when it's not, the perfect Super Bowl beer commercial kind of quality of life. It's like life is beautiful for a lot of different reasons, and avoidance of suffering is not only is it not the reason life is beautiful. Sometimes suffering itself is what deepens life, and so the fact that a different lie has taken hold is something that I think we should all try to be countering.
Yeah, that's a great and sobering reflection. I think in a call to action, right? To really be consistent on the dignity of the human person and the way that we teach, and especially that faith-based nonprofits are evangelizing and teaching the people they encounter. Um, so moving on to our last issue for today, there's an interesting case currently in the courts, and I think it's illustrative of one of the a couple of big legal trends that I'll get to in a minute. So in Houston County, Georgia, there's an employee insurance plan that explicitly excludes coverage for gender transition surgeries. Right? So, a county employee, a biological man who worked in the county sheriff's office, requested that the office pay for a surgery after he was diagnosed with gender dysphoria. Excuse me. I tried not to say that on the last issue, but I am still recovering from the flu, so I'm prone to occasional coughing fits. I apologize. Um, anyway, so the employee claimed, well, the employee had been diagnosed with gender dysphoria, asked for the office to pay for this medical procedure, and the county, consistent with their policy, refused. After which time the employee opened a lawsuit. He initially won at the trial court level in 2022. The case was appealed to the 11th Circuit. which last year did rule in the employee's favor. However, there was an appeal just recently to rehear the case en banc, which means the entire circuit, not just the 3-judge panel, but all of the judges would be present. And that petition to rehear the case en banc was granted. So the panel of judges just heard the oral arguments last week, so this is well underway. This is a really interesting argument. So the county argues that its insurance policy is not an instance of sex discrimination, which is the allegation here, since the county refuses to pay for quote unquote sex change surgeries for anyone, not just for women, not just for men. So let's get into at least what I saw here, and then I'd love to hear your thoughts on this one, Mary Margaret. First, as we said in our initial episode, this is a problem of, this is not tolerance, this is coercion, right? The reigning secular vision of the human person, the changeability of biological sexuality has established itself not in the name of tolerance. This isn't like, well, if people want to do this, you can't persecute them. This is, no, you don't have the right not to pay for their surgeries, right? Like, this is not a live and let live. This is a, you will bow down. You will agree that this is a good, solution to this person's ills, and you have no choice, right? This county has no choice. They must cover these kinds of procedures. So a decision has been made, right, by the regime in this case, that men can become women, women can become men, and there can be no dissent, and you must pay for that supposed reality, even in a county benefits package. So the other thing I want to point out, and this time more explicitly, but we've talked a lot about, and we'll continue to talk a lot about, the downstream effects of the Bostock case that was decided by the Supreme Court in 2020. This is overtly an issue related to Bostock because this is a Title VII discrimination case, which is what Bostock was deciding. So the argument here is interesting. The county employee, the attorneys for the employee claim that, well, this is an obvious case. Bostock controls, right? Because Bostock included gender identity in the definition of sex, right? Sex discrimination for Title VII. The county argues in response, no, Bostock was limited to hiring and firing decisions. And this is about a benefits package. This goes beyond Bostock. Now, this is interesting because they're arguing about how far Bostock goes and whether it applies to situations beyond hiring and firing. But I want to go somewhat deeper into it. It had been a while since I had read Bostock, so I was just reading through the opinion to get ready for this case today. But I think that even if you say that Bostock implies to sex discrimination for all Title VII cases beyond hiring and firing, I still don't think the logic of Bostock actually applies to this case. So if you harken back to 5 years ago when that case came out, the whole argument in Bostock was that it was sex discrimination because the employee was being discharged, but would not have been, right, but for that employee's sex. So if you remember, there were, I think it was 3 consolidated cases in Bostock, but the one I'm thinking of, it was a dress code issue, right? Where I believe it was a biological man who identified as a woman, I think that's right, wanted to wear women's clothes on the job. And the company said, no, we have a dress code. Men wear, I think it was the funeral home part of that case, right? The men wear the suits, women wear dresses, and that's it. And so now I don't want to go into the logic of Bostock. I think it was twisted and incorrect, but the argument was basically, well, this man wants to wear a dress to work, a biological man, right, identifies as a woman, wants to wear a dress to work. You're saying no, you're discriminating only on the basis of sex, because if that exact same employee came to you with the same exact request, I want to wear a dress to work, and that employee was a woman, not a man, then you would grant the request. So this is a sex discrimination case. Now, a lot of problems with that logic, but if we grant that logic, it doesn't apply here, right? Because what we have is an employee who says, I have gender dysphoria and I want a sex, a reassignment, sex change surgery to help with my gender dysphoria. When the county says no, that's not solely because of the employee's sex, right? If it was a man asking for this surgery or a woman asking for this surgery, they're just denying it, period. They're saying we don't cover surgeries, sex change surgeries for gender dysphoria. So the way I read Bostock is it just doesn't carry, that the logic doesn't actually hold here. And I think Justice Gorsuch kind of anticipated some of these problems. He says somewhere in his opinion that, well, people are saying, well, what about this case? What about that case? What about religion cases? What about, different scenarios with transgender healthcare. It's like, well, those aren't before us. We're just deciding what's before us. And Bostock did what it did. And now we're living in the post-Bostock era where we have a lot of really severe problems. So, like I said, I think there's a problem that there's no tolerance for an employer to make a decision about what healthcare they do and don't cover. This is a matter of coercion based on a certain view of the human person. And again, I don't even think the Bostock logic applies here. I'll turn it over to you and let's if you have anything to say. I think this is a fascinating one.
I couldn't agree more. I think this is a fascinating case, and like you said, Frank, an excellent opportunity to kind of distinguish Bostock. I do recall the same thing that Gorsuch did try to confine his reasoning to, like the base, whatever they say, the case on all fours or whatever, the case at bar. And of course, that's not what ended up happening. So I think this is a good chance to write the record. I think you're completely right that the logic kind of stops in this particular instance. There isn't really like an equal protection or a disparate thing. It's actually just a single process that's being excluded. So I think it poses a helpful opportunity to distill the issues down to their prime kind of their elements, and maybe restore some order to the very chaotic situation in the law here.
Yeah, it is interesting to note the makeup too. I'll just say procedurally. So this was just reheard en banc by the 11th Circuit. I think it's questionable. I think it's a pretty split. I know it was a majority Republican appointed circuit as of 2020, and then President Biden appointed, I think, two judges to that. So it's a pretty even circuit. Don't know how it'll come out. So maybe the en banc rehearing will lead to the end of this case. But I think it would be. I almost hope that the en banc rehearing affirms what the 11th Circuit said, because I would like to see this go to the Supreme Court and see, right, are they going to cabin Bostock? I don't think that there's appetite to overrule it, unfortunately, but this is one to watch. So we'll watch closely, and we'll obviously keep our listeners updated on what happens with this case in the coming weeks.
Thanks so much, Frank. And thanks to all of you for joining this episode of the Napa Legal Podcast. If you enjoy the content we are putting out, we would appreciate if you would like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you are listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues affecting religious liberty and the work of faith-based nonprofit organizations.
Talk to you all next week. Thank you for joining us, and God bless you.